If you know her, you know how thorough, well-informed, and well-received by employees she is. WERMC is looking for new members who want exceptional service from its carriers, brokers, and agents. The impartial advice of an independent risk management consultant, and those who believe sound loss prevention efforts are the best way to reduce their injuries, lawsuits, and costs. We'll be hosting some more webinars in the coming months. The next is December 13th, Workers' Comp 101, Understanding How to Control Costs. At that, I would like to turn this over to Kathy Johnson, the independent insurance consultant working with WERMC. Thank you.
Thank you, Erin. Welcome to everyone who's on the call. This summer, when 3 districts asked me to help them form and consult the new co-op WERMC because they wanted an independent consultant, I realized that I could find vendors that would offer them the resources that would give them the best of both worlds. Erin mentioned some of them with regard to dividend and so forth, but I saw the opportunity to find a vendor who was a national broker and have their own on-staff consultants to supplement the consulting work that I do. Also on that comment about Erin's premiums not increasing over 8 years, the liability carrier CIC has not had a rate increase in 8 years while we've seen the marketplace go up over that time. WERMC also has lower membership dues than what former members of the previous co-op were receiving. As Walmart would say, we've rolled back pricing on the consulting fees. On the workers' compensation, as she said, we work with RJF agencies, and we've seen impressive services from them already. They help you be proactive to prevent accidents. And the work comp carrier, State Fund Mutual, has a unique philosophy when it comes to loss control, which is helping you make culture changes which reduce accidents. And they also provide aggressive claim service that help control the amount that the claim will end up costing you and affecting your experience mod. So if you're interested in knowing more, just contact Erin or me. Our speaker today is attorney Ron Stadler, who's a partner at Gonzalez, Saggio, and Harlan in Milwaukee. Ron's an experienced attorney and advisor to his clients, practicing labor and employment law, education law, municipal law, and related litigation. He regularly advises private and public sector employers on labor and employment matters. Mr. Stadler has extensive experience in collective bargaining, union contract administration, grievance and interest arbitration, wage and hour issues, unemployment compensation, workers' compensation, the Fair Labor Standards Act, the Family and Medical Leave Act, the Americans with Disabilities Act, discrimination issues, hiring and firing issues, plant closing issues, and health insurance matters. Mr. Stadler also represents school districts and higher education institutions on all aspects of education law. His experience includes student discipline, special education matters, Section 504 issues, ADA compliance, teacher and administrator non-renewal, labor and employment law issues, collective bargaining, grievance and interest arbitration, board policies and governance, premises liability issues, and open meetings and public record issues. Mr. Stadler is a member of the State Bar of Wisconsin, the American Bar Association, the Milwaukee Bar Association, and the Wisconsin School Attorneys Association. He's also active in civic organizations. He earned his JD from the University of Wisconsin Law School and his BS from the University of Wisconsin in La Crosse, where he was a Harry S. Truman Scholar. Ron, would you present our webinar today?
Thank you very much, Kathy, and it's a pleasure to be here today to present this for everybody. As Erin indicated earlier, if you have questions, please type them in, and I'll be happy to take any questions as we move through the slideshow and talk about the presentation. Obviously, you've all signed up for this webinar because of your concern about Act 10 and Act 32 And you've all heard about it, you've read about it, and you've talked about it, I'm sure. This afternoon, what I'd like to do is to dig into it a little bit and talk about some more of the practical implications of the changes that we saw with the budget repair bill. I think the biggest surprising news for everybody with Act 10 as it came forward was that out of the blue, we have a new statutory provision in Wisconsin that says that, except as allowed under subchapter 4 of Chapter 111, a school board cannot collectively bargain with its employees. And that sounds fairly innocuous at first until you go to subchapter 4 of Chapter 111 and see what it provides. And that was, I think, the shocking part of the budget repair bill for everybody. And this, too, comes as no surprise to everyone because I'm sure that you have seen this and read about it. But the new statutory provisions make it a prohibited subject of bargaining for a school district to bargain over anything except wages. And when you talk about bargaining over wages, it's only the total base wages that can be bargained over. So there's nothing in the law now that allows you to bargain with your teachers, your support staff, or any other employees in regard to overtime or premium pay or merit pay. It's simply base wages. I think the other aspect of these new requirements that's also surprising to people and surprised a number of people is that the provision is that although you can bargain over wages, you can only bargain over wages in regard to a maximum cap of the Consumer Price Index, or the CPI. And if you look at the bullet points on the bottom of the screen that you're looking at on page 3, you can see that the statute now provides that if there's an increase in the CPI, you can bargain up to that increase in the CPI. But if the CPI has decreased or there's been no change in the CPI, you can't even bargain any further over wages. So very, very restrictive in regard to what is left in terms of the ability to collectively bargain with school district employees. The other aspect that I think is very worthy of noting, and one that you don't really hear about in the press a lot, but it's that contracts now can only be for a one-year period of time. And again, that's a statutory provision. So we not only have a very, very limited issue in regard to what we can bargain over, wage increases up to the CPI, but you can also only bargain for a one-year period of time. So again, very, very limited. The other interesting aspect about the new law is, although it's termed that teachers and other school district employees still have the right to engage in collective bargaining, when you dig into it and look a little bit further, there's not much left in there. When we take away the fact that it's a one-year contract, that you can only bargain up to CPI, you also have to look at the fact that if you're not able to reach a voluntary agreement, the statute continues to provide for mediation, which anyone who's had experience in collective bargaining in the public sector over the years is familiar with mediation. You have a mediator whose job is to help you resolve your dispute and reach an agreement. If mediation is successful, great, but the mediator cannot compel anyone to reach an agreement, and that's the way it's been for years and years. That's the way mediation works. In the past, we had arbitration then. If you don't settle the case at mediation, you go to arbitration, and an arbitrator makes a decision as to whether the school district's offer is the fair offer or the union's offer was the fair offer. What we have now with the changes in the budget repair bill is the ability to go to mediation, and the mediator has no power to compel a settlement, but after that, there's no arbitration. So we are left with a situation where the parties can bargain, they can disagree, they can go to mediation, and if they don't settle it at mediation, nothing can be done about it, and the district is free to implement whatever offer it believes is the fair offer. So if you look at that, you can see that we effectively in Wisconsin have little to anything that looks like collective bargaining anymore in regard to the public sector, and for those of you in attendance today, in regard to teachers and other school district employees. When the changes were first made, I think people started saying, well, how's that going to affect us? What's the new world going to look like? And obviously, one of the prime issues that we have is grievances. With no more contractual rights under collective bargaining agreements, we have to realize that there are no more contractual violations to grieve. And also, if we don't have anything to grieve, there's also no process to grieve. Grievances were contractually created rights that were set forth in your collective bargaining agreement. And so when the collective bargaining agreement either has gone away or will go away for those of you who are still operating under an agreement, so too goes away the grievances. The legislature did create some ability for employees to challenge discipline. You're required to have a grievance procedure available for your employees as of October 1, 2011. So if you don't have one yet, you need to make sure that you get a grievance procedure in place. If you have a collective bargaining agreement in place that has not expired yet, you'll be following that until that contract does expire, and then you too will need to have a grievance procedure in place. When you look at the grievance procedure, what the legislature provided was that you can establish either a civil service system or you can establish simply a grievance procedure. I'm not aware of any school district that has established a civil service system. Generally, people have gone about establishing a grievance procedure. And the requirements for what must be present in a grievance procedure is you have to have a procedure that addresses employee termination, employee discipline, and employee workplace safety issues. And you have to have a written document that sets forth the process that the grievant and the employer must follow. If you're familiar with what we always had in collective bargaining agreements, there were generally provisions in there within X number of days. An employee had to file the grievance. Within X number of days, there had to be a meeting between the employee and his or her supervisor, and then a response from the supervisor, and that could typically be appealed up through steps 2 or 3 or 4, eventually landing in arbitration. So you need to have a grievance procedure that sets forth in writing what those steps are going to be. The hearing itself then, no longer will we have the days where the parties have to select an arbitrator or call the Wisconsin Employment Relations Commission and obtain a panel of arbitrators. Now the hearing is required to be held before an impartial hearing officer, and that impartial hearing officer is appointed by the school district. Generally, in drafting a grievance procedure, you would set forth a procedure in there for selecting that impartial hearing officer and defining his or her responsibilities for conducting the hearing. If you get a decision from an impartial hearing officer, your grievance procedure then has to have an appeal process, and the appeal process is that it goes from the hearing officer to the highest level of the governing body in your local governmental unit. For school districts, that means that it would come before the Board of Education. And what I keep telling people is that if your grievance procedure now requires you to have a hearing in front of a hearing officer, and then the final word on whether you violated somebody's rights is a decision from your school board, and you lose that case, then you deserve to lose that case. Because I think most everybody can expect that if you take an action, it will be supported by your school board. When you look at that then and say, okay, we don't have to bargain anymore, there's no grievances anymore, the obvious thing that people say is, well, how else does that affect us? How does it affect my school district? And so I tried to list out a number of the items where we're going to see an effect from not having a collective bargaining agreement anymore. If you start on page 8 of the PowerPoint and look at that, school calendar. Remember the days of having to bargain over the school calendar and setting those days and setting forth everything in regard to that calendar. Those days are gone. Once your contract is gone, you no longer have the obligation, and you will have the ability to set the school calendar as you see fit. No more contractual restrictions on hours. Typically, we used to spend a lot of time at the bargaining table talking about when school was going to start, when it was going to end, the number of hours in the day, all of those things. Again, that can now be unilaterally set by the school district. There's no more contractual restrictions on workloads. We used to see language in the collective bargaining agreement talking about how many class periods a teacher would have to teach during the day, what was considered to be an overload, what kind of compensation would be provided for those teachers that took an overload. Those two are gone. Another one of the items is overtime, and you didn't see overtime typically with your teachers, but for your support staff, your clerical staff, or custodial staff, oftentimes there were contractual provisions that addressed overtime. And certainly a school district has an obligation to follow state and federal law on wage and hour issues, and you're required to pay overtime for hours worked over 40 hours in any given week. But typically we would see contractual provisions as well that would provide minimum call-in times. It would provide that you would get overtime for any hours beyond 8 in a single day. It would provide that you would get overtime for any hours paid beyond 40 in a given week. And one has to remember that there's a distinction between hours worked beyond 40 and hours paid beyond 40. If I took 3 days of vacation during any given week, those 24 hours that I was paid for vacation pay are paid hours, but they're not hours worked for time and a half purposes under state and federal law. So there's a big distinction there, and now school districts will be bound by the law and not necessarily by contractual definitions of what is overtime. Other things where we saw changes come down as a result of the budget repair bill, health insurance. Again, the school district is now going to have great unilateral authority in regard to health insurance and selecting carriers. We don't have the old language of making sure that the plans are substantially equivalent or anything like that. But I put on the slide there, and I hope you all remember that the legislature did create a provision in Section 120.12 of the Wisconsin statutes that provides that before a school district can change health insurance or obtain a health insurance carrier, it has to solicit sealed bids for the provision of those benefits. So make sure that you don't forget about that provision as you're out shopping for health insurance benefits. Likewise, prescription drug coverage, again, no more contractual restrictions or requirements on that. No more restrictions on life insurance, long-term disability, short-term disability, or dental insurance. Certainly, school districts have been provided now with a great deal of flexibility in regard to how and what it's going to provide on insurance benefits. Other things that have gone away, when you talk about leave of absences and provisions related to that, you no longer have contractual requirements on sick leave banks, personal days, professional leave, unpaid leave of absences, no more contractual requirements on family and medical leave issues. Certainly, again, you still have to comply with state and federal law in regard to family and medical leave, but typically we would see contracts where there were provisions that may have provided more generous family and medical leave or may have extended coverage to relatives that weren't necessarily covered under state and federal law, and those provisions are also gone. Other impacts, we always saw in collective bargaining agreements language in regard to professional improvement, when you had to evaluate a teacher, how often, what needed to be in that evaluation. That language is gone, but don't forget about Section 121.02 of the Wisconsin statutes. That section does provide that a school district has to evaluate in writing the performance of all certified school personnel at the end of their first year and at least every third year thereafter. That was fairly typical of language that we saw in collective bargaining agreements. The collective bargaining aspect of it is gone, but it's still a statutory requirement. In regard to duty-free lunch periods, teacher contracts always had in them provisions for duty-free lunches, allowing you to, as a teacher, to have a duty-free lunch every day. It comes as a surprise to people, but generally Wisconsin law does not require an employer has to provide a lunch break to employees. It's recommended, but it's not required. That is different for school teachers. Section 118.235 of the Wisconsin statutes actually provides that a school teacher has to receive a duty-free lunch period not less than 30 minutes in length, and it has to be provided at or near the time of the regular school lunch period. So again, not a collective bargaining obligation. It's not found in your contract anymore, but there is still a statutory requirement for your teachers that they get that break. Doesn't apply to custodial staff, doesn't apply to anyone other than teachers. Other impacts that we see with the elimination of collective bargaining agreements and the changes in the in Act 10 and Act 32, you're not going to have contractual restrictions or requirements in regard to extracurricular assignments. So who gets to be the cheerleading coach, who gets to be the football coach is no longer going to be governed by your collective bargaining agreement. Likewise, summer school assignments, extra assignments like curriculum writing, those things are no longer governed in a collective bargaining agreement. And you no longer have contractual restrictions or requirements on promotions or vacancies. So if you can think back to some of the language you've seen in collective bargaining agreements where you were required to promote the most senior person for a job, that too is gone, and you're going to end up having the flexibility to select the best qualified candidate based upon your determination of who's the best qualified. Compensation is also been affected. Teacher salary schedule was a creation of collective bargaining. So your starting rates, your lanes, and your steps, those are all going to be gone when your contract is gone, or if it is gone now. You no longer have those things to guide you in terms of compensation for your teachers. Items like tuition reimbursement, retirement benefits, no longer addressed by the collective bargaining agreement. Early retirement, post-retirement health insurance, all of those things no longer are going to be provided in your collective bargaining agreement and are not required to be provided to your employees. Certainly the Wisconsin retirement system is still set by state law, and you'll be required to adhere to that. But as you know, we've also seen substantial changes in regard to WRS requirements and the fact that the teachers now have to contribute towards their WRS contribution. Other changes, discipline and discharge. There's no just cause standard anymore. Just cause was a creature of contract and is no longer present. Under your new grievance procedure, the standard will be arbitrary and capricious. There is a huge difference between being responsible for a just cause standard and arbitrary and capricious. Arbitrary and capricious is basically, is there any basic reason as to why you did something and you didn't just pull your decision out of the air. So again, a very big change in terms of the life of dealing with discipline and discharge for public sector employees. No more contractual restrictions on layoffs. Your collective bargaining agreements always had language in them in regard to who would be laid off, who would be recalled, and how seniority was determined and how seniority affected who would be laid off. Those provisions are also gone. So when you look at that and you say, wow, my collective bargaining agreement is gone, life should be pretty simple, should be pretty easy, I've got no rules, no regulations, no hoops, who can complain about that? It's a great thing. My life just got a lot easier. Now, at first blush, I think that might be a good and logical conclusion. Usually no rules and no regulations means that life is a lot easier, but I think you can also look deeper into the changes and find that changes where you have no rules and no regulations aren't necessarily the easiest thing in the world. You have reason to be concerned. Without rules and regulations, there is potential chaos. How are your employees supposed to know what is expected of them? How do you know how to respond to any particular situation? If you don't have a rule that says when somebody is eligible for a leave, how do you know whether to approve it or deny it, or whether you should modify it in some fashion? The problem that results from not having rules and regulations is that lack of consistency. And when you don't have consistency, it can create problems. In the bottom of the slide on page 17 sets that forward, and that is, what's another word for inconsistency? And technically this probably isn't a synonym, but if you look to the next slide, it's discrimination. And when you have situations where you are not treating people consistently, people start to wonder, why is it that I was treated differently than someone? And if you look at the slide, you can see I've got the example on there. If my leave request was denied, but Jill, hypothetical Jill, was allowed the same leave request, then I'm going to start asking, well, why was it that hers was approved, mine was denied? Maybe it was because of my age or gender or religion, national origin, disability, sexual orientation. Wisconsin has a long list of protected characteristics, and when you start treating individuals inconsistently, they start looking for reasons, and oftentimes discrimination becomes one of the reasons that people look to or conclude was the basis for them being treated differently. The second point of that is that if I'm your employee and I disagree with your decision on my discipline or my discharge, or I asked for a benefit and you denied it, or you treated me differently, am I going to file a grievance under your new grievance procedure? I think the answer to that is going to be most likely no, that employees won't access that grievance procedure because they do have other options. If I'm your employee and I think you've treated me differently than other people, or if I disagree with your decision on my discipline, I'm going to look to be able to file a discrimination complaint against you to get some redress for the fact that I was treated differently. The employee's use of the discrimination complaint can be quite effective for them. It's free, doesn't cost them anything to file the complaint. It's easy. It's a one-page form where they can go down to the Equal Rights Division, fill out their name and address, your school district's name and address, check off a box that says that they were discriminated against and what the basis was, and then provide a relatively short fact summary, which does not take a lot. And it's going to cost you as a school district a lot to defend against it. From the employee's perspective, they're going to get a decision from a neutral, not from the school board, so there may be some great appeal there. When we talk about it being cost-effective for the employee, most grievance procedures that are being set up are requiring the parties to split the cost of the grievance equally, so the employee has to pay half of the hearing officer's cost. If there's a transcript involved, half the cost of the transcript, whereas going down to the Equal Rights Division, it's going to be free. So I think everybody needs to be aware of the potential that as we move forward in life without labor contracts, that we're going to see the possibility of more discrimination cases being filed. The bullet on the bottom of page 20 is one that I just wanted to make sure that I mentioned, and that is being aware of the latest trend that we are seeing, and that is retaliation claims. And we're seeing actually more retaliation claims than outright discrimination claims. So we're not seeing an employee coming forward and saying, you know, I was discharged and it was because of my gender or my age, etc. We're seeing people coming forward and saying, you know what, I opposed discrimination, and as a result of my opposition to the discrimination, I was then retaliated against by being discharged. And we're seeing a lot of those claims being made, and they're very difficult claims because oftentimes it's the employee's claim that he or she mentioned discrimination to somebody else, and that it was in a close relationship to the time when they were terminated or other job actions were taken against them, and that becomes their basis for the claim of retaliation. Make sure you keep your eye out for retaliation claims. If you're getting written documentation, either a memo or an email from someone where they make mention of potential discrimination, you need to make sure that you pay attention to that. I've had several cases recently where employees have simply sent emails saying, you know, I saw this going on and that's discriminatory. It's really something that our company shouldn't be involved with. And later when that person was fired, they've come back and used that as the basis for their claim that their discharge was in retaliation for having opposed the discriminatory actions. It doesn't take a lot of opposition for them to get that kind of protection, and you need to be aware of that. When we talk about avoiding uncertainty and inconsistency, I think the starting point has to be issuing a memo to employees, assuring them that your district is taking the steps necessary to address the changes. For those of you whose contracts were expired and you started on July 1 with the new budget repair bill provisions, I'm sure you've mostly done this already. For those of you who have contracts that have yet to expire, give some thought to this, and that is just letting your employees know that you do intend to address the changes mandated by the law, and that although their collective bargaining agreements will be going away, your district is really going to be ready to talk about those changes on the day that they become effective or even beforehand. and again, reaffirm to them your district's dedication to providing employees with a fair and equitable workplace. Just simply good public relations moves to try and keep your employees calm as they face the uncertainty of living without a labor contract. Beyond that, certainly one of the things that you're going to have to do is to establish work rules and policies which are going to apply to your employees, and that's all of your employees. It'll be your teachers, your support staff, your custodial staff, whoever you have working for you, and make sure that you can provide your employees with certainty and consistency by having those work rules in place. Things you need to be aware of if you are going to create work rules and policies. Don't create situations where you lose your employment at will status. Generally, you want to make sure that somewhere in those policies and procedures that you create, that you put in a provision indicating that everybody is still employed at will, and that nothing that is said or done can create an expectation of continued employment or a contractual relationship. You also want to give yourself flexibility to deviate from those rules and policies. Always remember, deviation is inconsistency and can lead to claims, but there may be times when, although you have a general rule or a general policy in regard to a subject, that you need the ability and the right to be able to deviate from that. So make sure you preserve that to yourselves in your policies and procedures. Make sure that your policies and rules meet the needs of every department or classification that you have. Sometimes there isn't a one-size-fits-all, and I was trying to think of some examples of this as I was getting ready for the webinar today, and I think the one that pops into my mind simply is snow days. On snow days, you may not require your teachers to report to school, but you may require your custodial people to report to school because they're going to have some snow cleanup to do. So just keep in mind that there will be situations where not every policy or every rule fits the needs of every employee. And then the last bullet on the bottom of page 23 of the PowerPoint, if you do create new work rules and policies, train your supervisors, your managers, department heads, whoever it is that's in charge. Train them on how to implement and live with the new rules and policies. Make sure that they know what they mean. Make sure that they understand the process and they understand what's being required of employees under all of your rules and policies. In the last part of this, I wanted to talk about some particular problems that are created by the loss of collective bargaining agreements. And as I said at the beginning, I think the first natural reaction for everyone was, wow, this is great. We no longer have a collective bargaining agreement that ties our hands. But on the other hand, I think if you look at those 5 areas that are on the slide, you're going to see that there are some things where maybe a collective bargaining agreement wasn't so bad. Those issues are employee discharge, layoff, sick leave banks and payouts, early retirement, and salaries and wages. When we talk about discharge and when we had life under the collective bargaining agreement, everybody remembers, you could only terminate a teacher or non-renew them if you had just cause. Well, obviously, we no longer have just cause, and that new standard is arbitrary and capricious, which is a much easier standard to meet. The problem is we're going to run into conflict between the concept of discharging a teacher and the requirements found in Section 118.22 of the Wisconsin statutes, which is the non-renewal language in the statutes. The non-renewal language in Section 118 really gives you 2 options, and that is to either non-renew a teacher on or before March 15th, or if you don't non-renew them, the language of the statute provides that the contract then in force shall continue for the ensuing school year. That can be a problem. We had in the statutes Section 118.22 sub 4, which said that a collective bargaining agreement can modify, waive, or replace anything in 118.22. Nobody was required to do that, but you could have a collective bargaining agreement in place that would modify 118.22. Sub 4 was deleted in Act 10, and it's no longer there. I think the logical part of that is is that since there are no longer collective bargaining agreements, you can't have a provision that says that a collective bargaining agreement can modify or waive or replace the provisions of that section. That language, however, becomes problematic because we no longer have statutory authority to modify or waive 118.22. If we don't have the ability to modify, waive, or replace any provisions in 118.22, your options are to non-renew by March 15th, or else that contract continues for another year. The statute itself doesn't contemplate a mid-year discharge, and I'm sure that all of you can think of some example in the course of your careers where you've had a teacher who is either engaged in misconduct or has had some event happen in their life where there was a discharge in the middle of a school year because the school district thought you had just cause. Well, that provision was allowed under your collective bargaining agreement. Under 118.22, there is really no recognition of a mid-year discharge. I think we're going to have to wait and see if school districts can seek to go into court to void a contract on a breach of contract principle, basically arguing we agreed to employ you as a teacher, but by you engaging in this conduct, you've breached your end of the contract. It's an open issue, and it's not one where I think there's a real clear answer at this point. The other implication under 118.22 is in regard to layoffs. And again, layoffs were created by collective bargaining agreements, and they were authorized by 118.22 sub 4. Well, we don't have the collective bargaining agreement anymore, and we don't have 118.22 sub 4 anymore. And without those two things, there is no such thing as a layoff. Under 118.22, you either have a contract for the coming school year or you don't. Once the contract is issued, there's no ability to lay off. And that seems, I think at first blush, somewhat of a harsh conclusion, but we have seen the same result under Section 118.24, which is the administrator non-renewal statute. And I'm working with a school district right now where I wasn't involved in the original issue, but they had an administrator that they laid off, and the administrator challenged that in court and said, you can't lay me off under 118.24 because there is no such thing as a layoff under that statute. You either have a contract or you don't. And the circuit court judge has agreed with the administrator and said that the layoff is not a right to terminate the contract, and that employee was entitled to all of her compensation under that contract. So I think that's a huge potential also under the new rules. That is, we don't have the ability to issue layoffs, and you really have to think of layoffs more in terms of a non-renewal, making your decision before March 15th and because of the notice requirements before March 1st of any given year as to whether you're going to need that employee to come back in the next year. And that's the first bullet point on the next slide makes that point. And the other aspect is in the second bullet, and that is that court decisions have held that the procedures under 118.22 cannot be waived by teachers, that there's a public policy in favor of those procedures. So even if we were to try and go and create individual employment contracts with teachers to create some sort of a layoff procedure, I think previous case law and the elimination of 118.22 sub 4 would preclude people from being successful on doing that. More implications of life without labor contracts, sick leave banks, sick leave payouts, and early retirement. Certainly those aren't going to be things that are going to be bargained anymore, and there'll be no contractual language on that. And that, I think, creates the issue of what do we do about employees who have an existing sick leave bank or who operated for years under a collective bargaining agreement with a sick leave payout policy, or who operated for years with an early retirement policy in place. And I think that there's a number of different ways to look at that in terms of the way that employees are affected differently. If I've been a teacher in your district for 20 years and during the first 19 and a half years of my employment, I had a sick leave payout policy in place that said that if I banked 150 days, I'm going to get them paid out at the end of the time when I retire. What do you do now? Can you simply terminate that and say, you know what, we're not going to offer sick leave payout anymore, or we're going to change the number of days in the bank? Or for those of you eligible for early retirement, I know we had a policy in place that said if you were here 20 years and you wanted to retire, we'd pay you X amount of dollars, or we'd pay you additional money for health insurance benefits. Can you change those? And I think that for most people, the answer to that is going to be affected by what's known in the law as vesting issues. And that is that at some point in time, people become vested in those benefits, and you can't simply take those benefits away or eliminate them. I think there's going to be different scenarios for different benefits and different ways that people are situated. Certainly, I think if you're an employee who was told that you could receive X early retirement benefits after 20 years, and you've been with the district now for 25 years, you may have the ability to say, well, you can eliminate the policy, but you can't take away my benefits. On the other hand, if you've been employed in the district for 10 years and you're not at the 20-year mark yet, some people would argue that you'd be entitled to half of those benefits. Other people would argue that you wouldn't be entitled to the benefits because you haven't completed the 20 years and the policy went away before you reached that milestone. So I can't give you a general answer in regard to everyone's situation, but I think that if you're looking at changing sick leave banks, sick leave payouts, and early retirements, you certainly need to go over that with legal counsel and make sure that you're addressing the vesting issues for all of those. Wages and salaries, another area where we're going to see some issues come up. If the collective bargaining agreement goes away, you really have no structure for establishing wage or salary increases. And so you have to ask yourself, what are you going to do? Are you going to have across-the-board increases? Are you going to offer merit pay, performance bonuses? I don't think there's any right or wrong answers, but you need to have an answer, and you need to make sure that you address that. It seems to be that that is one of the biggest issues that gets people riled up these days, is they simply don't know what's going to happen for them either this school year or next year in regard to, are they going to get an increase? Are they going to be rewarded for getting additional credits? And you need to be able to come up with answers for them on that to provide them with that guidance. Questions. That leaves us about 10 minutes for questions and answers. Is there anybody that has questions? Anybody busily typing away their questions?
Ron, am I broadcasting? Can you hear me?
Yes, I can, Aaron.
I have a question, and that would be, is the law new requiring school districts to do sealed bids for health insurance, or has that been around for a while?
It's been around longer than Act 10 and Act 32, but I think no one was very aware of it.
Ditto.
In fact, I was surprised when I found it in preparing for this.
Interesting.
And it's only directed to school districts. It's not a requirement for cities, towns, counties, villages, only school districts.
Ron, this is Kathy. I just sent you an email regarding the involvement of workers' compensation and collective bargaining.
Okay.
Did you get the question?
Yeah, I'm just getting it now.
Okay, good.
If districts continued wages or allowed sick leave to be used to ensure continued wages, what changes in the way workers' comp is managed for the employees? Obviously, anything that was created under the collective bargaining agreement could be continued, but does not have to be continued. And I think one of the things that we often saw were contractual provisions that the school district would make up the difference between the workers' compensation benefit and a person's normal wage or normal salary, and that is no longer the case. You can do it if you want to, but that was a contractual item that was created by the collective bargaining agreement, and you no longer have to do that. And I think most of your workers' comp carriers would probably prefer that you're not doing that, because when you were subsidizing that difference, it was an incentive or probably a disincentive for people to return to work. They ended up saying, well, I'm making 100%, I might as well stay on workers' comp.
I'm familiar with a district that is now, you know how the workers' comp law has a 3-day waiting period before the employee will be paid for disability on the 4th day, and a district that is now having the employee suffer that 3-day waiting period without pay. They're allowing them to be able to use sick leave for those 3 days if they want to, but if they're not off long enough as to what the work comp law dictates, they will have those 3 days without pay.
Okay.
Is that something that you're seeing districts doing?
Some are, some aren't. It's, you know, it's going to depend on the district. We have more questions. Here's one. What is the status of the legislative proposal to modify 118.24 to include a layoff window dated May 15th? I don't know what the actual status of that is right now. I know it's been discussed and it is floating out there. It would be actually to modify 118.22, which is the teacher statute. So hopefully we will keep an eye on that. The good news is the legislature has made sure that our taverns can open up at 6 a.m. to sell beer for tailgating. But there's a lot of other issues that they haven't taken care of. So we will need to keep an eye on that. Another question was, any idea when the definition of base wages will be published? And again, that one hasn't been defined. That's a huge issue that people are struggling with right now, is what does it mean, base wages? Does that mean base wages for all of your employees? Does it mean base wages just for that collective bargaining unit? You know, and what's entailed in that? It's undefined at this point in time, but hopefully the legislature does provide us with some additional guidance on that so we can figure that out. Another question is, what if we have an insurance broker manage the insurance? I'm assuming they should still get sealed bids, and should they be provided to us? I would say yes, even if you're having a broker, if that broker is engaged on your behalf to obtain health insurance, you would need to follow that statutory requirement in terms of obtaining the sealed bids. Another question, does the bidding requirement also apply if you are negotiating a renewal? Can it be required that if you are bidding, you are required to take sealed bids? I don't think it would be if you are negotiating a renewal with your existing carrier, but I think if you open it up to other carriers and before you go out and look to shop around to switch, that then you would be required to take the sealed bids. Any other questions? I'll give everybody a few minutes to type any further questions if you have that. We will be doing another webinar on claims about retaliation for opposing discrimination in early 2012. I kind of touched on that briefly here today, but I think that that's the kind of detailed information in that webinar that could definitely help you avoid those kind of claims. And also, we'll follow this webinar with links to the presentation and a recording of the webinar So if you want to be able to see the screen again, the PowerPoint, and to be able to listen to the webinar itself, you will have the ability to do that. Anyone else have any questions? All right, going once, going twice. If there's no further questions, I'll turn it back over to Kathy and Aaron.
All right, this is Erin. I'd just like to thank everyone for tuning in today. Remember, December 13th at noon will be our next webinar, Workers' Comp 101, Understanding How to Control Your Costs. So we hope to see you all then, and thank you for tuning in today.